Talk Show. Recorded live.
Good evening, everybody. It is Wednesday, October 7th, 2015, and we are here tonight with Bob Schaefer. And Bob Schaefer is one of our researchers and coaches at youhavetheright.com. And we have these conference calls edited up by subject, also in our monthly membership. So if you guys are wanting to learn more about Bob's stuff and you want it in a quicker, more organized manner, go to youhavetheright.com and join up. We'd appreciate it. And we also have Bob Schaefer's Do-It-Yourself Land Patent Kit available as well. So go to the website and check that out. So, hey, Bob.
Yes.
All right. So we're going to continue on with tonight's agenda. Why don't you tell us what that is real quick?
Okay, well, we're going to talk about land patents tonight and the awesome power of a land patent.
Oh, real quick, you guys, before we get started, if you'd be so kind as to hit *6 on your phone to mute out. That way we don't pick up any background noise and disruptions about the call. It would be appreciated. And if you ever have a question, you can hit *8 to raise your hand, and when it's time to take questions, we'll get to you. So, all right, go ahead, Bob.
Okay, well, the first thing I like to do from time to time is say if anybody listening to this conference call is an officer, agent, or employee of any federal, state, county, or city government, including judges and prosecutors, you are welcome. We want you to know what we know. I have trained a lot of judges and prosecutors over the years. Sometimes they have to lose in court, but I don't want to have to go that way. If we can just all get on the same bandwagon, then we can understand. I usually tell people, we can talk in your office or my office or before a jury. I don't really care. But we use their law against them. This is their law, and they're bound by it. The intent of the original lawmakers binding on today's constitutionally valid courts of record and today's administrative law tribunals, which is what most of the courthouses are today. They're not really courts of record. A court of record, according to Black's Law Dictionary, is a court that proceeds at the common law, and they hate the common law. The common law is, by the way, the only law system under the law of the land, the basic law of the land, and until 1844, that's all America was based on, everything. Now then, there's a few quotes I want to mention from time to time. In fact, it's good if people could write them down. And by the way, I throw so much information out that it would be good if you could record these conference calls and then go back and listen to them. You'll hear more the second and third time than you did the first time.
Hey, Bob.
Tell me.
Yeah, these calls are recorded, and they are at TalkShoe, so people can listen to them, and I have them archived in my members section by subject.
Oh, good. Well, some people actually record them and put them, and they take them to work with them and listen them on their little tape recorder or their whatever they have in their car. Anyway,
and you can download the recording from TalkShoe and do that without having to record it. So we'll do that. Yeah, we'll do that for you.
Okay. Now there's another quote that is very important. We use it almost daily because we use it, and that's a quote by Vince Lombardi, the coach of the Green Bay Packers, and he made a statement that was good on the football field, but it's also good on the battlefield and in the courtroom. And that quote is, "The best defense is a good offense." In other words, when somebody sues you, you turn around and you give them a compulsory cross complaint. Many courthouses will put the compulsory cross complaint ahead of their complaint because the second complaint is likely to resolve both issues or both sides. So it's really good to be ready to strike back, and you've got to be ready, and that's what these calls are about, is learning how to be ready, because you can't go out and learn what I've learned in 36 years in the next week or two. But you can pick it up a little at a time. I give people the high points of my knowledge, the stuff that's the most important. So anyway, we'll get on with the land patent thing. The land patent is part of what the Founding Fathers gave to themselves and to their posterity. Now, that would be their children and grandchildren and great-grandchildren and us, because the way the laws read, it doesn't specify just their own heritage. The Founding Fathers gave themselves two major things, and that was sovereignty for themselves and sovereignty on their land. They were truly a little nation unto itself. That's where America got the reputation of a man's house was his castle, because he was the king. He was the king on his land, and we were known as a country of sovereigns with no subjects. Now today's government, they hate people to think that they're sovereign. No, they're not sovereign. We're sovereign. We can tell you what to do and when to do it. But that's not the way it is. Now, as a former general contractor with 3 other license classifications, I've provided jobs to over 400 families over the last 56 years that when I started in business in June of 1959. And I understand the master-servant relationship. In other words, nobody that works for me is going to tell me how to run my business. Mm-hmm. And so that's why being sovereign is so important. But now you can't go and tell some police officer, you're just a public servant, you're working for me. Keep in mind, he has the gun and the badge, and he can make life miserable on you. I recommend you cooperate with everybody. And then you can hit them later with a lawsuit if you need to. But we don't do frivolous lawsuits. We only do lawsuits that are required. And I mean, I've sued judges, and they're still my friends because they know they needed to be sued, and it helped them learn. So sovereignty of the people and sovereignty of their land. Now, the sovereignty of the land came down this way. The federal government wasn't even a federal government for 9 years after the Declaration of Independence, from 1776 to 1787. And that's 11 years. There were just the 13 original colony states. So those constitutions were first. And then they came up with a constitution for the United States of America, which was basically shall we call it the guard shack, to protect the 13 colonies. The 13 colonies couldn't come up with a navy that would protect the coastline or a coast guard. And so the federal government was put in place for that purpose. It also produced a national money supply and a national postal service. And that was basically where it started and stopped. The constitutions, both federal and state, are nothing more than a contract that people who work for the government place themselves under. In other words, if you're going to work for the government, you have to sign a contract. It's called an application for that job. And you swear an oath to uphold that Constitution. And I want you to swear an oath to uphold that Constitution because it binds you. It binds all government people. It doesn't bind anybody else because they don't have that contract. America's a nation of contracts. And so the sovereign people, now they're not going to like this, but the sovereign people were above the law. That's just a fact. Because on July 5, 1776, there were no laws. But the people were sovereign. And they took some of their sovereignty, known as a clipped sovereignty. Imagine you're in a barber shop and they clip some sovereignty off of you and they create something else that's somewhat sovereign. and is sovereign in its own right, like with the nations of the world and with the states. And they are sovereign for people who place themselves under the constitutions. And that's why when you go into court, a judge will say, do you understand the charges? And what they're really saying is, do you stand under the charges? And you thought he meant, do you comprehend the charges? They know what they're doing, by the way. This is not just new to them. And so they take advantage, they take unfair advantage of the ignorance of the people. I was taken advantage of. I used to own a beautiful historic hotel called the Hotel California on the corner of Main Street and Route 66 in downtown San Bernardino. You couldn't get more downtown than Main Street and Route 66. It was next to the city park. They had the cannons and the statues and all that, and the big dining room with arched windows looked out across that big, huge lawn. They went around a federal restraining order and they leveled it. It's a parking lot today. And that's the reason. That is the reason I started studying law seriously. In fact, it was very anti-productive. I laid off 28 full-time employees and closed down my retail store and branches in 5 towns and got rid of my 5 new truck payments just so I could afford to study law, because the attorneys I hired didn't know what I know now. If I would have known then what I know now, that hotel would be up and running. Best Western Hotels were going to pay us every month to run it for us. And there was another thing, too. They sold my house that I was raised in, and I bought from my parents for a sales tax that I didn't know at all. But my attorneys dropped the ball. And so, one of the things attorneys learn in law school is how to pass the test. They're not taught law. They're taught how to pass the test and procedures and stuff. So anyway, the Founding Fathers gave themselves these 2 wonderful things: to be sovereign on their own right and to be sovereign on their land. Nobody could come on their land and tell them how to use it. We were talking earlier about it's illegal to collect the rainwater off your roof. Not on my land, and I'm going to collect whatever water I want to on my land. I understand there's people in Northern California that are suffering from the government putting a meter on their well. Well, that's a lawsuit as far as I see it, because you own to the center of the earth and to the center of the sky, and you can control all of that. Now, you can't control airlines. Those rights are already there. They have air corridors and things like that. But that's just a basic statement that you own to the center of the earth and to the center of the sky. It's very old case law they came up with before they had airlines. Anyway, there are people today that say, well, these constitutions are archaic, they're old, they need to be changed. And my answer to that is, well, then change them. There's a provision. The Founding Fathers realized that as society grew, changes might be needed. So they made the amendment procedure. And you can amend these constitutions, but today's people don't want to go through that hoop. They want to just change it with what's known as judicial activism and get the judge to see it your way and forget the Constitution. And that's what we see today in a lot of government agencies. So that's when it comes time to sue them and demand a trial by jury. Now, a lot of people don't understand the difference between a jury trial and a trial by jury. Remember earlier I mentioned courts of record and administrative law tribunals. The acronym for that is an ALT. And a judge that runs one of those is an administrative law judge or an ALJ. And they know all this, and that's what they are. They're not true judges. They're administrators under administrative law. Now, back to the land patents. They are very easy to get, and they're very inexpensive to get. I'm looking right now at a receipt that I just got this last week. I ordered 4 land patents. They were all 1 page they charge $1.10 per page and 25 cents per document to certify it. So four land patents cost me $4.40 plus $1, at 25 cents each, a total of $4.50, and they paid the postage. Now, how hard is that? Now, the way you get them, you contact the Bureau of Land Management. Now, the National Archives, they, for some reason, maybe the one that's near me, well, it's about 40 miles away. They don't issue, have land patents, but they have a court case that backed up the land patent. So I go to the Bureau of Land Management to get the land patent, and I go to the archives to get the court case. You see, in California, they had over 720 Mexican and Spanish land grants. It was actually 20 Spanish land grants. They were huge. They were into the square leagues. That's enormous. And they were given to encourage settlement, and they were given to soldiers and settlers. And that was over a period of 313 years. Then, in a period of 40-some years, the Mexican government issued 700 Mexican land grants. Now, that came about by the International Treaty of Guadalupe, Hidalgo, and its Protocol of Prairie Terrell. That was from 1848. By 1851, our Congress said, we don't know where they are. So we have to, we're bound by that treaty, so we better do something about it. So they passed the Act of May 3, 1851, entitled An Act to Ascertain and Settle, that's a key word, the private land claims in California. And it gave them 2 years to bring your documentation over here to this committee, look it over, and we have to issue a land patent, because that's what the Protocol of Prairie Terrell was all about. See, when the original treaty was presented to the Mexican government and back to the Americans, Article 10 said that we, in America, would recognize the Spanish and Mexican land grants. But our Congress said, why should we do that? We just beat you. And so the Mexicans said, well, we're not going to sign your treaty. So they sent Mr. Trask back to Mexico, and he negotiated the Protocol of Prairie Terrell, and that is in our favor because it makes it even more powerful. They're not going to just recognize it. They are going to recognize it with a United States land patent. That's how powerful that is. Well, our government still didn't like us very much, and so they only recognized 3 out of 720. That shows how evil they were. These people showed them their documentation, and they just were finding fault with it. And so that meant they had to go into the court system. Now, the federal court system has had 3 different names that I know of. It was at one time the Federal District Court, then it was the District Court of the United States, and then it's the United States District Court. Well, that's what we have today. About 30 years ago, when I filed my first case, I titled my document the Federal District Court, because I'd read a lot of case law about what happened in the Federal District Court. And the clerk said, well, we're not the Federal District Court anymore. We're the United States District Court. So I had to drive all the way back to my office and change the title of my document. Anyway, there's information out now that the United States District Court is only good for territories. It's not even a valid court system. And so if somebody is being prosecuted, let's say criminally, in the United States District Court, I believe we can help them point out that the court system is invalid. But then we use that system more or less like a church court. In other words, with a church court, if both parties agree, then it's binding. But you can't force somebody into a church court. Just like some people came up with common law courts, and they were trying to get back to the law of the land in common law courts. Well, they did work with when both parties agreed, just like a church court. Well, that's the way we use the United States District Court today. We all agree to use it. And so then when we agree, then it's binding, even though it's not really a valid court system outside of the territory. See, it's a valid court system in Guam, Puerto Rico, the Virgin Islands, American Samoa, and the District of Columbia. And that's one reason the word district is involved, is because it's a district of Columbia Municipal Court. And then what they did over the years, while the people were asleep and having another beer and watching the game,
yeah,
they came up with the Zone Improvement Program called ZIP, and they have the Zone Improvement Program code called the ZIP code. You get mail to a ZIP code, don't you? Well, I don't. I say I put it in care of, and so I can get mail in care of that ZIP code, but it's not mine. I don't attach myself to any zip codes, but that's what the Zone Improvement Program, it's a federal zone. It's an overlapping jurisdiction all over the United States. They came up with the act, the Buck Act of 1940, and it refers to in this state, and the word state is capitalized instead of lowercase. So they're talking about in this overlapping state, and most people don't even pick up on that. The words and their meanings are critical, and the spelling of those words is critical. Then, so we have this overlapping jurisdiction. Then earlier they had the Act of 1871, which is when they created the United States Incorporated, which was another term for the District of Columbia. And like I mentioned in the past, the United Nations has a representative that says the United States, does not say the United States of America. So it's representing the corporation. It's not representing the States United. And so we have to understand all this. Now, sometimes when in a court case, I quote federal case law, even in state cases, because they're federal corporate states now in this state, this uppercase state. And all states have two constitutions. There's the original underlying common law republic constitution that formed the state originally, the freely associated compact states, and then there is the overlapping states that came about after 1871. California's 1879 Constitution, and that's spelled in all uppercase letters. It's a corporation. Corporation names are spelled in all uppercase letters, just like other dead legal entities. Years ago, I was an embalmer. I worked in a mortuary, and we had to fill out death certificates. The name of the deceased was in uppercase letters. We were instructed that it had to be that way. You go into a cemetery, the tombstones have everybody's name in uppercase. They are dead. And in Great Britain, they called them lost at sea. And they weren't lost at sea. That's the way it's called a fiction of law. They create a fiction and then they run with it, and they don't tell you that it's a fiction. And it all looks real, and because of our own ignorance, we don't pick up on this stuff. That's why it's so important for us to know all these. These are little details. So these 717 cases that were not recognized by this committee were recognized by the court system. And that's a good thing, because now we have a judicial determination that says this land is patented, and it's patented pursuant to these laws. Now I'm going to read you one of these land patents, because it says the words that we're looking for. This is a land patent that was issued on the 16th day of January in the year of our Lord. The year of our Lord, they were Christians, you see. And a lot of people say, well, the First Amendment says we have a right to freedom from religion. No, it's freedom of religion. So here for all these years they've been using in the year of our Lord, 1,919. This one was issued in 1919 by Woodrow Wilson, President of the United States of America. And here's what it says. On the very top has a title, the United States of America, and then below that to all to whom these presents shall come greetings. The writing is a little small here. Whereas a certificate of the Register of Land at Los Angeles, California. Now this land patent is good for Cherry Valley in Riverside County, in San Bernardino, in Riverside County, California. But in those days, this land office was in Los Angeles. It has been deposited in the General Land Office, that's the GLO, and by the way, the Congressional Township Survey all over America uses GLO instead of BLM because it was the General Land Office until 1947. So it's been deposited in the General Land Office, whereby it appears that pursuant to the Act of Congress of May 20, 1862, quotes, to secure homesteads to actual settlers on the public domain. That's the title of the law. Now you see, they were not interested in land speculators that would just go out and get a lot of land and then sell later. It was specifically to secure homesteads to actual settlers. That's a key word there, on the public domain. And the Act supplements thereto the claim of John F. Goff, that's Goff. So Mr. Goff had this land patent originally. It has been established and duly consummated in conformance to law for the north half of the northeast quarter, the northeast quarter of the northeast quarter, and the northeast quarter of the northwest quarter of Section 28. And I'll explain that later about all these definitions. Section number 28 in Township 1 south of Range 2 west of the San Bernardino Meridian, California, consisting of 160 acres. So 160 acres is 1/4 of a 640 square mile section. And it just said it's Section 28. And that's one of the things you will need to find, and I'll explain that later too, how you find your section so that you can order your land patent. You can do it over the phone, give them a debit or credit card, and put it in the mail for you the next day. According to the official, and then it goes, according to the official plat of the survey of said land returned to the General Office by the Surveyor General. So see, the Surveyor General of the United States of America surveyed all the land all over America. It was not the Surveyor General of the state, because it was the United States that owned all the land due to all the treaties and purchases that were made. And then it goes on. It says, now know ye that there is therefore granted by the United States unto the said claimant the tract of land above described to have and to hold the said tract of land with the appurtenances therefore unto said claimant and to the heirs and assigned. Key word. You're assigned. You assigned it to yourself. And then you assigned it with your mortgage, you assigned it to the mortgage company. And I'll tell you how you can get it back, or how it came back already, probably by operation of law. But anyway, the assigned is critical. We have to use that word a lot. Of said claimant, the assigned of said claimant, and then the word forever. So when somebody says, well, that's an old document, good night, that goes back 100 years ago, almost. Yeah, but it uses the word forever here, so the question becomes, what is it about the word forever that you don't understand? It's subject to, now here's the one thing that we're really looking for on every land patent. Subject to what? In other words, there's some exceptions here when it's subject to something. Subject to any vested and accrued water rights. That means they were already there, by the way. It doesn't mean anything in the future. It means that they're subject to what was already there, because what's there first is paramount. for mining, agriculture, manufacturing, or other purposes, and rights to ditches and reservoirs used in connection with such water rights, as may be recognized or acknowledged by the local customs, laws, and decisions of courts. Now, remember, I just said that before this was issued, the decisions of courts are still binding right here on the document. There's an old maxim of law that says what is not said is sometimes more eloquent than what is said. So if there is no reservation of rights on a land patent, there is no reservation of rights to anybody. But when there is a reservation of rights on a land patent, it's only to the federal government because it's the one that issued this document. And so again, what is not said is sometimes more eloquent than what is said, leaves the state, cities, counties out of this. This land patent transferred. I've got case law that says it was a quit claim. Quit claim says you have everything I have. So the United States of America said Mr. Goff here has everything they had. Well, what did they have? The public domain was where the United States government had the highest form of ownership. The highest form of ownership. The federal government had all rights, title, interest, estate, use, and control. We call it the allodial title. There's no higher title. Look it up. Look up allodial in your law dictionary and look up allodium. It's called the title held in allodium. So the question becomes, where did the state of California get any right to tell me how to use my land? Because the state is not mentioned in this reservation of rights, neither the legislative, executive, or judicial. The judicial is left out in the cold, too. They can't tell you what you can do on your land because they're not mentioned on the land patent. That's one reason they hate land patents so much, is because of what I'm teaching you here. And so the federal government could come back in and put in ditches and canals and for flood control. See, when the Surveyor General was out, he could see that there was a big alluvial fan coming out of a mountain over there, and so that means we should probably come back someday when we have some money and put in some flood control. So right on the plat map that he's drawing, he puts D/C. So if you're looking at a plat map and you see D/C, you can go to the actual land patent and see where a reservation of rights was given to the federal government to put in ditches and canals. Okay, moving on here, it says, and there is reserved from the lands hereby granted. Now it's reserved only to the federal government. The state is not mentioned here, so it's more eloquent by not saying it. Hereby granted a right-of-way, thereon for ditches and canals constructed by the authority of the United States. Well, it says it pretty plain there. So earlier we talked about ditches and reservoirs for the water rights that were already there before 1919, and then for ditches and canals for the federal government to put in flood control. Then at the bottom it says, in testimony, I, Woodrow Wilson, President of the United States of America. Now, you see, he's claiming to be the President of the United States of America, even after 1871. Caused these letters to be made patent, and the seal of the General Land Office to be hereunto affixed, given under my hand in the District of Columbia, the 16th day of January in the year of our Lord, 1919, and of the independence of the United States, the 143rd. So 143 years after July 4th, 1787. And then there's a signature. It says, by the President, Woodrow Wilson, and it has his signature. But then it also says by, and then there's another name here, Secretary. So the Secretary might have signed the President's name, but it doesn't make any difference because they have the authority to do that. And then there's another signature, Recorder of the General Land Office, some guy named Samuel. Now, this particular land patent, it says record of patents, patent number, this is what's critical, 659669. There's 6 numbers, though. This is a late one, by the way. The land patent on one of my pieces of land is number 481. Just 3 letters, 3 numbers. So it's really important that you get your land patent. And by the way, there were 6 different ways the federal government released its public domain land. And the public domain land was all the land outside of the ranchos. The federal government had no business setting foot in a rancho. And there's a system of maps here in California. It's called Thomas Brothers Guides. And I collect maps as part of my 9,000 law book library. And about 2000, Thomas Brothers started showing the ranchos with a dot-dash red line. And if you know what you're looking for, you can look at a page and you can see there's no section numbers inside the rancho. So if you see section numbers, then that land is outside the rancho. Now, to describe how land is recognized in land patents and all legal documents. To start, centuries ago, the mariners came up with the latitude and longitude system. And they used a sextant to read the stars, and they would place it on the horizon of the ocean, and they could tell where they were. My great-grandfather, 7 generations ago, was Captain William Clark, co-leader of the Lewis and Clark expedition, and that was his job to map the journey, and he used the stars. He had mountains in the way. He couldn't look at the horizon, so they had what they called a false horizon, and it was the best they could do. And so the way they did what they did, they took the globe, the world, and they divided it into 360 degrees. A circle is 360 degrees. So if you're looking down from the North Pole, imagine 360 little lines going out to the edge of the world. Line number 0 is in Brunswick Village in England. And you go 1 degree to the right, you have 1 degree east. If you go 1 degree to the left, you have 1 degree west. Until you get all the way around to the other side, the opposite side of the earth, it's 180 degrees. So there's your half of your 360. You go halfway out there, you have 90 degrees. So if you raise the right arm up and you point out that side of the earth, you go out 45 degrees, that's 1/4 of the planet. Now then, that was just like slices, like if you peel an orange, you have an orange that has slices that are narrow on the inside and wide on the outside. But the Earth has 360 slices that run that way, and they go from narrow at the top and the bottom to wide at the equator. Now, how did they do the other way? They call them parallels. You have a circle around the North Pole, and you have a circle around the South Pole. It's called the Arctic Circle, the Antarctic Circle. Well, you come out 1 degree, and then you do another circle. Now, that circle is parallel to the first circle. The first time I even heard about this, I was 10 years old, and I didn't understand it at all. But when I was 10 years old, we had the Korean War, and the North and South Korea were divided at the 38th parallel. Everybody knows that, but a lot of people don't know what a parallel is. Well, it's parallel to the Arctic Circle up at the top and parallel to all the other slices through the Earth. So those slices are 1 degree apart, but they never touch each other. They're just run parallel with each other. Well, that's the latitude and longitude way of orientation on the planet. Then they came up with 2 other ways. The Congressional Township Survey was based on, for the land patents. Land patents are not based on on the latitude and longitude, which, by the way, is called meets and bounds, and it can be used as a legal description. You can do it. You can use it that way. So to get the land patent, you need the township, range, and section. Now, here's how that works. The Surveyor General would come out in San Bernardino, where I am. We have Mount San Bernardino. And there was a man named Colonel Henry Washington that worked for the Surveyor General of the United States of America. Well, San Bernardino Valley was a desert. It was just a desert. We have a lot of trees and shrubs now, and we use a lot of water, but before that it was a desert. I collect antique picture postcards, and I have one that's taken a picture of Mount San Bernardino in 1903, before there were any cars. And there was all this haze. You could just see the top of the mountain out of this filthy air. And then below it, it showed shrubs. It showed desert shrubs, sagebrush. Now, this was taken right about where Norton Air Force Base is today. Now it's called San Bernardino International Airport. And the two words at the bottom describing the picture describe the two different things that we're talking about here. It said desert haze. They were just showing how the haze comes in the valley. Well, the haze is produced by the sagebrush. It's a natural phenomenon, but you could not see through it. It was air pollution that cannot be controlled by any government law. So in 1903 is when this picture postcard was canceled, but the picture was taken before that. It could be a year or two, when the photographer took the picture and made the picture postcard. So we've had air pollution, natural air pollution, for years. And but basically, back to the desert thing. San Bernardino Valley was a desert. It was very hot, and so they couldn't survey it. If they had transits in those days, they could look through the transit, and they get nothing but a heat wave showing up. Everything was moving around. And so they decided, we've got to do this at the cool of the day. So they went up on Mount San Bernardino to build a bonfire that could be looked at through a transit in the night. So they did the survey in the night when it was as cool as possible. Well, when they got up there, they found there was a peak that stuck out in the way of the survey. So they decided, well, we're the ones that decide where we're going to put this initial point, and that's where they stuck the sword in the ground. That this is the initial point for the entire survey of all of this whole area, which would be Southern California. And so we can move it from the peak, the highest point, we can put it out there on that other peak. And today that's known as Washington Peak, named after Colonel Henry Washington. So they put the initial point there. Well, what goes through the initial point is normally a baseline that runs east and west. So the baseline runs through the valley of San Bernardino to the ocean. And there's a baseline road. There's baseline roads all over America, by the way, and they are all tied to the baseline of this survey we're talking about. The baseline also runs over to Arizona, to the Colorado River, perfectly east and west. And what they did, they took readings off of the stars, the North Star, and there were 7 different readings where they decided that they would be able to set up this baseline. Now then, on the meridian line going north and south is 90 degrees. Remember, we talked about 90 degrees in the 180 degrees. And so, if you're looking straight west on the baseline to the ocean, and you put your right arm up to the right, you have the meridian north. You put your left arm up, you have the meridian south. Well, they found that was almost impossible to survey because of cliffs in the area. And so they went back 500 feet from the initial point. Now, this is very, very rare. I took a surveyor with me to find these. I had to see them and photograph them. And why did they do that? And I didn't know why they did it until I got there. And the surveyor, I asked him, he was a neighbor. I said, you want to go with me up to the initial point? He says, I'd love to. He says, to a surveyor, that's like going to Mecca. I want to go there too. So, and his specialty was finding hard to find markers. And so he was able to find these markers, and we determined why they were where they were, because if they went back 500 feet, they missed the cliffs. and they could go down a draw into Mill Creek Canyon. Then they went back another 200 feet to go the meridian north. From then on, everything has to be exactly 640 acres for each township. So the first township, they went out 6 miles from the initial point, went out 6 miles, and that was the edge of a township. A township is 6 miles square with 36 square miles inside of it. 6 times 6 is 36. So you have 36 sections, 1 mile square sections. A section is 640 acres. Your land is in a section, and it's already been surveyed. You don't have to survey it. It's already there. The land patent has already been issued. All you have to do is obtain it, and then you can claim the forever benefits of the land patent. That's why this is so important we're talking about tonight. I claim the forever benefits of Section 28, and nobody can tell me what to do on my land because I'm the king on this land. Now, are they going to say, oh, Mr. Schaefer, you've got a land patent. Sure, have a nice day. We'll leave you alone. No, that's not going to happen. So it's a court battle, but you're going to win because this is well-settled basic American law. You know, back in elementary school, high school, and college, I hated history. I thought, who cares? That already happened. But I'm finding now, in the 36-year study that I've made, that history is so important because we can take advantage of what those founding fathers did for themselves and for everybody else. See, the Congressional Township Survey was done so the federal government could inventory its assets. It owned all this land. They needed to know where the coal was and where the oil was, if they could, and where the bad water was and where there was grass. So as the soldiers would go across the country, they had to go from one pasture to another. I have a map of going from Los Angeles to Massilia, New Mexico, where Billy the Kid was killed, and there was a lot of treaties were signed there, and so it was a major thoroughfare for the Army. And it's so interesting. You had to go to this place, and it had water for your horses, but no grass. So you had to take your hay along. But then when you went to the next night, you had grass but no water, or vice versa. It was very interesting, very detailed, so that the traveler could know what to expect, which way to go, and how to get from one point to the other. Because they didn't have GPS systems and streets and highways. It was all on the back of a horse or walking. So now here we have this initial point. All surveys have an initial point with a baseline running east and west and a meridian line running north and south. Okay, the first square, 6 mile square off of that on the south side would be a township, it'd be Township 1. And then the second 6 miles would be Township 2. The third would be Township 3. And this is shown on these Thomas Brothers maps. You can see, they'll tell you right where the townships are. Now, as you're going to the ocean, you go 6 miles from the initial point, and you start another range. Those are called the ranges. So that first square, the first township, is Township 1 South, Range 1 West. The next one is Township 1 South, Range 2 West. And it gets all the way up to about 18 west before it goes into the ocean. You go in the other direction, the same thing. Township 1 South, Range 1 East. And the whole state is covered up with this grid of townships. Now, in the township is 36 sections. Now, east of the Rockies, they numbered them differently. They were still 36 in a 6 mile square, but they mapped them differently. If you're looking at a township, let's just say we're in a classroom and I've got a board in front of me and I draw a square. I draw a line down through the middle in both ways. Now I've got 4 quarters of that square. If I put 2 lines going down on each side of that center one and 2 lines above and below. I've got 36 squares. We'll put the word N, or the letter N, up at the top. North is always at the top. I should say almost always. There's some really old maps, they didn't get this yet. But in modern day, north is at the top. We'll put an S at the bottom underneath the square. That's the south. The right side will be east, and the left side will be west. That's why Rush Limbaugh looks at the map of the United States, and he calls us the left coast, because it's on the left. and it is full of people on the left.
Yeah, right.
And so anyway, now we've got 36 squares. If you go to the top right, I'm telling you this so you can know how to get your land patent. This is critical to get your own land patent. At the top left square is number 1. Next to that, to the left, is number 2, and it goes all the way over to section number 6. Then it drops down. 7 is under 6, and it goes 8, 9, 10, 11, 12. 12 is under 1. Then it drops down to 13, and it zigzags back and forth like that until the very last one is on the right bottom, and that's section number 36. This is important because Section 36 became a school grant in the future, as did Section 16. Some other states had forced school grants. It's called SGs. Now, when you're looking for your land patent, you might find that your land patent is an SG. It's a school grant. The state gave, the federal government gave to the state to sell to raise money for the schools. Now, here's how that worked. When California became a state of the Union on September 9, 1850, the federal government released some of its land to the state. Now the state was land poor, didn't have anything, and it gave the state a burden, actually. It gave them all the river bottoms and the lake bottoms that were navigable and the ocean out 3 English miles. And the burden was, if a ship goes down, you got to get it out of the way for those sovereign people to be able to use their river for fishing and business. And so the state of California was a year old, and it owned no land except what it bought for its own buildings. So it could control nothing. Now then, they were bound by these ranchos, 720 Spanish and Mexican land grants. So they had to figure out where they were. And so that's part of the Congressional Township Survey, was for the Surveyor General to find where they were so that they could stay out. I had a friend that worked for the Surveyor General for a while, and he was told, we don't go in ranchos. We're told to stay out. Don't go in to change your dog. Don't go in to find the bush. Don't go in a rancho. Stay out of the rancho. If something happens to you in a rancho, we're not coming in for you. You got to understand. So outside the rancho was the public domain land, and the federal government was holding it in trust for those sovereign people. I've got all kinds of case law and laws on the sovereignty of the people. So even though the government today doesn't allow us to think we're sovereign, that's what we are. Now, we're not sovereign citizens because you have to step down from your sovereignty to place yourself under a government constitution, but by contract to be bound by the chains of that constitution. And then you become a citizen person. Person is a key word. A lot of people think, well, I'm a good person and that's a good person. No, you're not a person. You're not a good person. You're not a bad person. A person is a privileged legal entity created by the government. Corporations are persons. Partnerships are persons. Associations are persons. And people who step down from their sovereignty to go work for the government for the day, they are persons. And they are citizens until they go home. When they cross that threshold and go out to office and they head for home, they're sovereigns again. Back and forth. Those sovereigns at night, most of the time, and above the law, they're not under any laws except the common law. And the common law is based on reasonable logic and common sense, based on also on custom, usage, practice, and procedure. And those are the words used in the case law. So in other words, you can't kill somebody. That's a violation of the common law. But if you kill somebody while you're at work, now you violated the penal code because you placed yourself under all those codes. Now, there's two kinds of laws in America. There's constitutionally valid laws, and then there are administrative laws. You need to know this, especially if you're a judge, because you got it wrong. You think, for some reason, you think everybody's under all laws. Well, show me a constitutionally valid law that says all people, not persons, all people are under all laws. It's not there. And so the constitutionally valid laws are really, 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 I emphasize, hard to pass. We use the P word. They have to be passed, and they start out as a bill. They go into one of the two legislative houses. In the state, it's the Senate and the Assembly. In the federal government, it's the Congress and the Senate. So they're a bill. Anybody can submit a bill in either house. This new law gets read to the whole house. It's called the first reading. Then it gets sent to committee where it has a second reading. Then they hammer it out. They say, well, we don't like this word. We want to add that word, and they make it to where they're happy with it. Then they take it back to the main house, and they have the third reading. Then they vote on it. They might pass it, and they might not pass it. So that's the first hurdle to get through. If it gets passed there, I use the word pass again, it goes to the other house where it has a reading. They read it, that's the first reading over there, or the fourth reading altogether. Then they send it to committee, and the committee either likes it or they have some suggestions. If they like it, they send it back to the House, and they have the third reading over there or the sixth reading. If they make changes, it has to go back to the first house. And they have to have the three readings and back to committee until they all agree. So both sides, both houses agree that this is a law that we need. And by the way, that law is going to control the government. It's not going to ever control the sovereign because it uses the word person. They all use the word person. Now then it has to be signed into law by the governor or the president. He can veto it. This is called the system of checks and balances. So we have a system of checks and balances in America against bad laws. So the governor or the president can say, I'm not going to sign that. I'm not going to sign that into law. That's a bad law. Well, his veto can be overcome by a higher percentage of vote in those two houses. And if that happens, then it has to have an effective date. It has to have a publishing date. And there's another date. What is it? A date of enactment. A date of enactment, a date of publication, and an effective date. You know, this law comes into effect on January 1. Now then, that's just the first of the three-branch government in our system of checks and balances. Now the police officer on the street can say, I'm not going to enforce that law. That's a bad law. He doesn't have to enforce the law. It's his choice. But yet now the police officer is told, you know, your paycheck is depending on you writing some tickets here because we need that revenue. And so there's a fat chance to kind of not enforce that law. But it does happen. You know, I was a sheriff for 7 years, a deputy sheriff. And I'll tell you, I got special treatment. You know, I was riding my motorcycle home in the mountains, and I was really enjoying, you know, in the curves. That's a lot of fun. And I got the red light on me, and the sheriff pulled up, and I pulled my hat off, and he saw who I was. He goes, "Oh, just I want to tell you to keep it, you know, slow it down a little bit." Oh, okay, I'll do that. He could have wrote me up, but see, he chose not to. And they can choose not to. It's okay. But now if he wrote me up, then it goes into the judiciary. That's the third branch of the system of checks and balances. The judge can say, I'm not going to enforce that law. Now, see, they found this out, how powerful this was during Prohibition and the repeal, because there was a lot of judges which just wouldn't do it. You know, the police officer brought the people in, and the judge was having his bootleg beer in the back room, and he wasn't going to nail that guy that made it for him. So he could choose not to. But now the founding fathers said, we still don't trust judges. We can't trust anybody. We're going to leave the last in the system of checks and balances with a jury of our peers. And it has to be people that know us, our own peers, people from our neighborhood, people that say, I know Bob. He wouldn't violate a law that he was under. And so they are the last in the system of checks and balances, and that's called jury nullification. They nullify that law at that time, at that instant. Now, what's happened since the Act of 1871, we have this federal corporate system that overlaps all of America through the Zone Improvement Program code, or the zip code, and they're using the courts for revenue. In San Bernardino, we have the original San Bernardino County Courthouse. San Bernardino County came about in 1853. It broke off of Los Angeles County. Now then, they have another courthouse that used to be diagonal across the street called the County of San Bernardino Courthouse. And I just found the charter for the County of San Bernardino. San Bernardino County was formed in 1853. The County of San Bernardino was formed in 1912. The question becomes why? Well, it's because it was a federal corporate county. It's all in uppercase letters, too. Now they just built a new courthouse. It's absolutely beautiful. It's the tallest building in town. It doesn't belong to the county. It says San Bernardino Justice Center. It doesn't say county anything. Same thing out in Palmdale. They have a new courthouse there. It's the Los Angeles Courthouse. But over in Los Angeles, they have the Los Angeles County Courthouses, and they have the County of Los Angeles Courthouses. So you see, there's all these jurisdictions all over the place. In Riverside County, they have the historic county courthouse. It's absolutely beautiful. It is a work of art, and it was just restored maybe 20 years ago now. It's been a while. And there's a plaque on the front. It says, Riverside County Courthouse, restored by the County of Riverside. Another jurisdiction restored that old courthouse because they're using it. And they're tricking everybody that walks in the door thinking it's the old original courthouse, and it's not. And you will not get a trial by jury in that courthouse. But say, you want a jury trial, we have to pay a fee. No, you don't have to pay a fee for a trial by jury. It's part of the legal system. But you pay a fee to get a jury trial. And with a jury trial, the judge will say, I will judge the law. See, they're protecting their revenue. I will judge the law. You, the jury, will judge the facts. So they become known as the fact finder. And no, we don't want a jury trial. We demand a trial by jury. That's an appealable issue. If they don't give us a trial by jury, we can go up on appeal. The beauty of a trial by jury is really very important. If you look at the Seventh Amendment, it says that the decision made by the trial by jury has no appeal. It's over. It's done. You get on with your life. You don't have to spend more money going up on appeal. With a jury trial, you can appeal that. So if you ask the judge, if I don't like your decision, can I appeal it? If he says yes, you got a jury trial. You didn't get a trial by jury, and you get that transcript and you use that against him in your appeal because you demanded a trial by jury and they gave you a jury trial. You've got to understand the difference. This is critical. And so what we do is set things up. Everything I do is a setup for a win someplace. You're not going to get it right away. Like, for instance, we have what we call an offer to pay. And we'll talk about that on another conference call, but it's a setup. Sometimes the judgment, it works against court judgments, it works against school loans, and it works against IRS and the Franchise Tax Board, and it works against everything where money is created as new money. That's not my term. That's the Federal Reserve in their book, Modern Money Mechanics, which you can get off the Internet. It talks about new money. It's where they create new money. So when they create money from nothing, they're not out anything, are they? They have no skin in the game. It's just plucked from air. So we make an offer to pay, and those case law on an offer to pay, and we use that against them. And so I'll get rid of judgments with the offer to pay by using their law against them. It's their law, and they're not real happy about it, but it's too bad. They're the ones that put themselves under the constitutions with their application contract to work for the government and be bound by that constitutional contract. Now we're going to go to the other kind of law. So there's administrative laws, which is where they are. Administrative laws deal with persons. You look at all the codes. In California, we have 29 codes now, and they all deal with persons. They deal with people that work for the government, that have a contract that places them under those laws, and they're bound by the chains of the Constitution. But they would like everybody to think they're bound by it, and they're not, and we're not. So we've got to. This is an argument to present before my trial by jury. This is why they've never given me a trial by jury. I can teach 12 people to think like I do because I can explain it to them, and I do seminars all over America, and I explain it to people like I'm doing right here on these conference calls. So we're not under the administrative law, but that's what they are today, is an administrative law tribunal or an ALT.
Hey, Bob.
So all the codes in California are administrative laws. They're not constitutionally valid laws.
Hey, Bob.
Now, the 1879 California Constitution had an effective date. The effective date was repealed because in the book it says for the effective date, see Article 20, Section 12, I think it is. You go look up Article 20, Section 12, and they still have it there, and it says repealed on this date. So that whole Constitution was repealed, basically.
Hey, Bob.
So
hey, Bob.
Maybe that's why they say we don't have to do the oath of office that's spelled out there. But that's the oath that they have to take, and they don't take it.
Hey, Bob.
So we use that against them, too.
Can you hear me?
Anyway, I'm open for questions now.
Okay. Yeah, I just wanted to know if you were ready for questions or not.
Yes.
Okay. You guys?
Yes.
*8 on your phone if you have a question for Bob. Just hit *8. Chirp, chirp. And then I'll bring you up on the system. Okay, somebody in Texas? Go ahead.
Hey, this is Mike in Texas. Thank you, Bob, and thanks, Tad, for arranging this call.
You bet.
So, Bob, as a former landowner in another state and as a former land surveyor in my first career, that mecca of surveying that you described is absolutely fascinating, really fascinating. And considering George Washington and some of the other founders were also land surveyors, they firmly and absolutely understood these principles. So the question I have is in regards to, does each state have its own original landmark where the surveying point started from?
And well, the answer to that is that it was made the Surveyor General's decision on how best he could survey the land for the Congress for the least expense. Now, Texas is interesting because it was not one of the first 13 colony states, but it was a state before it joined the United States, and it does not have any United States land patents. It has state land patents, and you have a land patent office over there. Now, how they did their survey in Texas, I don't know. But so that'd be easy to find. You can look it up, go to any surveyor law office, and have all your answers made. But yeah, they issued land patents, and they reserved rights to the state. Now, in California, we had. I didn't get there, but we can talk about it a little bit here. The federal government said on September 9, 1850, that we're going to give the state of California 500,000 acres that they can sell and issue state land patents to raise money for the University of California. And we're going to also give them 150,000 acres that they can sell. And it's not in one lump place. It can be anywhere in the state, and then you just pick and choose, and you deducted 150,000 acres for the agriculture and mining school. Then here's the SGs, the school grants. Section 16 and Section 36, that's the one in the far right-hand corner, bottom corner is Section 36. Section 16 is about in the middle. Those were to support the California elementary schools, and then the money was to be put in a trust for that support. I don't know if it's still there or not. Usually when people put money in a trust like that, they use the interest to run stuff, but they might have blown it like they've done a lot of other stuff. But, yeah, Texas is a little bit different, so you'd have to find out just how they did their survey.
So the question I would have then, any caveats when looking to buy property in Texas? Anything that would be a one-off on your process?
Well, I would find out the township range section number. I would call the Texas Land Patent Department. I would get the land patent for that particular area. You don't claim the forever benefits for the whole land patent, by the way. That'll get you put in jail. People went to jail 30 years ago when I first learned about this for claiming the whole land patent. No, you claim it as it relates to your legal description.
Okay. Yeah, because obviously the tract of land may not encompass the entire land patent.
Right.
Okay, great.
So well, you want before you buy anything, you want to find out what you're getting, and you'll find a reservation of rights on there. Maybe not. If there's no reservation of rights, even the state of Texas didn't reserve any rights, and that means everybody stays away. Go away, leave me alone. This is a nation unto itself. Here's my land patent. What is not said is more eloquent than what is said. You're not mentioned here. Neither is your state, city, or county. Now, if it reserved any rights at all, it would be to the state, and it has a legislative, executive, and judicial, and so you can find out what was reserved to the state. That's the main thing I look for on a land patent. First is number. I look for the forever word, and it's on every single one. Sometimes it's the last word on the whole page. I mean, I've read a lot of them, and there it is. It's the last word.
So you have to make sure that when you apply for your land patent or claim it, I don't know what the right term is, you must use the legal description from the deed for the property and make sure that that is the description that you use because you're describing that portion of that land patent.
That's exactly true. Now, that brings up another thing. There's a lot of people on the Internet teaching land patents. I guess they think they can make some money out of it. And making money is an okay thing to do, but they're teaching people wrong. There's one group that talked about you have to create the land patent sandwich, and that is you go back and look from the date the land patent was issued to your title, and everybody in between. There might be 20 or 30 different owners, and you look for problems. Well, why would you want to find a problem? As far as the record downtown is concerned, I'm the owner of this land. Nobody else is claiming it. I'm going back to that original and claiming the forever benefits of the original, and which left you guys out. I say you guys, the government. It left you out. And so I'm claiming that forever benefit. If you want to go find a break in the chain of title, that's fine, but I'm not going to waste my time doing that. It takes a lot of time and money to go look to create a land patent package. It was totally a land patent sandwich, I should say. It's totally unnecessary. I've been doing this for 30 years, and I've got all kinds of successes without doing that.
Wow.
So, yeah, you're right. You're right. You just take the legal that you have, and now there's some people that did a survey, and they do meets and bounds and claim that. And that's okay, too, because the government recognizes both meets and bounds, but it's okay to use their description when you're talking about the land patent. Now, here's an interesting thing a lot of people don't know. If your deed says that you own lot number so-and-so, tract number of the certain subdivision, you own to the center of the street. Always. The neighbor across the street owns to the center of the street. I won a court case on what I'm telling you right now, because the prosecutor didn't know what I was doing to it. Anyway, You own to the center of the street. Now, if you have if your legal description says from this point, so many degrees, so many minutes, and so many seconds to that point, and then you go to another point, so many links and chains. See, the original surveys with chains that had links in them, so they would say so many chains and so many links in that direction, and you go all the way around. It could have 8, 10 sites. Back to the point of beginning. That is your land. Has nothing to do with the center of the street. So when you look at a legal description, look for lot number, tract number, subdivision, so-and-so, and you own to the center of the street. So they can't come and tell you how you can't park your motorhome on the street. You're using your land. Okay?
All right.
Amazing, Bob. Thank you.
Thank you very much. Okay, Montana, you're next.
Hi, my name is Mark, and I attended a public meeting here not too long ago where there was a highfalutin lawyer from New York, and the question was asked, somebody asked a question about land patents, and I was surprised at the answer that the attorney gave. He said, the question was along the lines, should everybody get a land patent to protect yourself from all sorts of things? And basically the lawyer said, no, a land patent only allows you to defend your land against the adjoining property owner's land next door to you. It doesn't give you any rights and so on that apply generally to, all land patents, but that's very different from what you're saying.
Yes, it is. And by the way, if you believe that, then he got his way.
Yeah.
See, he's part of the system, and I tell people, if you have a really good lawyer or a really good CPA, you don't need any other enemies because they're there. They're an officer of the court, and their first duty is to the system, and they're going to come up with that kind of cockamamie stuff.
Yeah.
There's no case law. There's no case law that says what you just said, or what he tried to get people to believe. There's no case law to that.
Thank you for answering directly.
It's against the government. That's what it's against. I've got all kinds of cases. I've got hundreds of cases that say it's against the government. It's not against your neighbor.
Yeah.
Right. Thank you.
You bet.
Thank you. Maziar, you're next.
Okay.
Good evening. My question for Bob is a state citizen the same thing as a sovereign?
A state citizen is in commerce. I don't claim to be a state citizen. Now, the guy that produced state citizenship seminars and stuff, he's a friend of mine, and we disagree on that area. We disagree on who owned the land. He said the state of California owned all the land after it became a state. And I pointed out, well, then why did the federal government have to give the Yosemite grant to the state of California for its first state park? The state of California owned nothing until the federal government gave it to them. And so, same thing. So I'm not a citizen of anything. I might be a citizen of heaven, but I'm not a citizen of anything else until I place myself under when I was a sheriff, I was a citizen's person when I was on the job. And then I regained my sovereignty when I went home. I know a bus driver. I heard of a bus driver that had his Class A chauffeur's license to drive his bus. But then when he got back to the bus barn, he'd put his license over the sun visor and he'd get out, and he would not drive home. He would travel home. He didn't need no license to travel home. He needed a license to drive someplace. Driving is under those administrative laws called the vehicle code. See, code means hidden meaning. So they've got all these hidden meanings. And I'm not under any code. And I would challenge any judge to tell me when he's at home, is he under the Harbor and Navigation Code at all whatsoever? Absolutely not. He's above that law.
Right. I'm aware of all that. My question is state citizenship basically a kind of standing that puts you in the republic rather than a resident of a corporate state?
I don't think so. You know, that's why we disagree. My friend and I disagree. I don't think there's anything. You're a state citizen when you become a state citizen person and start working for the state. And the republics are not there now. I'm an officer in the republic whenever it might come back. I'm a very high officer in the republic, but I've been a high officer since September 23, 1910. Excuse me, 2010. But it's not. It has no authority. It's not doing anything right now. We hope it will someday. We're ready. We're organized. But I'm not under any of that until it comes into fruition.
So you don't believe that the several states of the Union are republics today?
They are there. They're underlying. And but you can still be protected by that 1849 Constitution in California as an inhabitant. And the way you do that is that you're not under that control. You're not under the chains that bind those people that work there, but you can hold their feet to that fire. In other words, I'm an inhabitant. I admit to being a native inhabitant of the California Republic. Now, this officer is messing with me. He's got the chains that bind him to the Constitution. I'm going to hold his feet to his fire. I'm not under that law. He is. Now, when I was a sheriff's deputy, I was under those laws when I was on the job.
All right, does that answer your question?
Yeah.
Okay.
Yeah. All right. Thank you.
All right. Thank you.
Thanks.
Okay. Next line.
Let me make a statement here, Ted. Citizenship has its obligations, duties, and responsibility to a higher authority. A sovereign has no one higher than him except his creator.
I see.
If you don't believe in a creator, then I can't help you.
All right. We have somebody in Florida next. You're on. Go ahead.
Hello.
Hi.
I spoke to you earlier. Now, how do you work a land patent with a condo?
Well, I did that already for my nephew, and that is when you bought your condo, did they give you full disclosure that you were waiving your land patent rights to buy into that?
I would have to go look at the paperwork and see.
Well, they didn't. They didn't. You see, whoever developed that condominium got the forever right as an assign from the original land patent. Could have been a homesteader or a railroad grant or a cash entry or a desert entry or a military warrant. There were 6 different land patents. And so if he didn't tell you that you were waiving that right, then you own the center of the earth. Now, I went up against a homeowners association for my nephew, and it's on Ted's. The interview with my nephew is on his site. He got a check for $10,000, and they paid for the attorney fees just to get him to leave him alone, because they knew we were going all the way to Washington because we were under administrative law. We're not under. They sued him. And we did a compulsory cause complaint. Now, then they were looking over their shoulder. See, the best defense is a good offense.
Okay, but do you do it the same way as you do any other patent? My question would be: I'm on the second floor. There's a 3-story building. How do I own the guy below me?
I didn't understand that.
I say I live in a 3-story building, and I'm on the second floor. How would I be able to do a land patent?
Oh, your place is on the second floor?
Yes.
Well, first of all, let me tell you, you're going to run into some grief. So if there's any way you can comply with everybody and keep everybody smiling, I would highly recommend that. But like with my nephew, they were trying to evict him because he didn't pay for the $2,800 to get rid of the bark beetle infestation that killed a lot of trees in that subdivision. And so we had no choice. But, you know, it costs a lot of money to fight. And they know it, and usually, until recently, governments had the money, and they took advantage of the poor folks. But now is a really good time to be suing the government. But I wouldn't be suing a homeowners association unless I just absolutely had to, and that would be the argument that I've already had success with. He didn't waive his land patent right to the center of the earth when he signed that contract. That contract did not give him full disclosure of that obligation.
So would that be automatically you have the land patent, or do you still have to update it?
You have to claim it. It's automatic.
Okay,
it's already there. People say, "Will you help me get a land patent?" I say, "I don't get anybody a land patent. The land patent's already there. It's been there for 100 years, maybe 200 years. We just claim the forever benefits that went to that original guy."
Okay.
All right.
And that's all on your site, right?
Well, the story of my nephew's telling a story.
Well, that's okay. I have other places besides the condo. I have other house. I have a freestanding house.
Okay.
So I wouldn't worry about the condo because, like you said, it might be too much grief.
Yeah.
Because I got a guy up above me and a guy below me. And
See, let me make a quick comment here. Sometimes it's the principle of the thing that drives us, and sometimes it's a business decision. And now,
so this could be a business.
Yeah, I agree. I do that too. For instance, you know, when they charged you $16 for a traffic violation, it was just cheaper to go pay the $16. And now when they want $80 for it, that makes me want to fight it. So you're right. You're right, making business decisions as well as moral decisions.
Okay.
All right.
All right.
Thank you
very much.
All right, Montana, you're next.
Hey, Bob. I heard you talking about the houses in the federal government. You said there's a Congress and a Senate.
Yes.
Well, guess what? Congress consists of a House of Representatives and a Senate.
You're right.
And I keep hearing people talking about Congressman so-and-so and Senator so-and-so. Hell, they're both congressmen.
Yeah, that's right. You're very, very right. I stand corrected.
And you're not alone. There are a lot of people keep referring to representatives as congressmen.
Yeah.
But then they'll turn right around and refer to somebody else as being a senator. And I think, you know, we really need to watch.
Well, let me interrupt you. They call themselves congressmen.
Well, that's on them.
They call themselves congressmen, and the other people call themselves senators. But technically, you're right. In other words, nobody says I'm a House of Representatives.
Well, if he was referring to himself, he would call himself representative, not House of Representative.
Yeah.
But, that's just one of my quirks. I was listening to the other guy from Montana, and he was talking about the lawyer that didn't understand the land patent. He said it was just a protection from neighboring landowners. I have learned that there are two classes of people that don't understand land patents and have absolutely no interest in learning about them. One of them's a lawyer, and the other one's a realtor. They have absolutely no interest in learning the law. And I was in attendance at the Montana State GOP convention, and I approached 3 lawyers there and offered to acquaint them with the land patent and the value that the land patent brings, and they didn't want anything to do with it. I said, look,
that's very true. You're very correct. You see,
got a collection of court sites that talk about deeds or color of title, and there's no superior to a title to a land than a land patent, and they didn't want to hear about it.
Well, you see,
that woo-woo stuff.
It cuts into their money because they can't make any money doing what I do.
That's right. Well, Bob, I want to cheer you on. I've enjoyed listening to this. I came on late because unfortunately the timing was conflicting with some things here at home. But this will be recorded.
Yes.
And I'll be able to go online and hear what I missed. And I want to thank you for this.
You can also go to youhavetheright.com. You click on the little preview button and click on Bob Schaefer's name, and you can see some of the conference calls I have up already. I'm kind of late. I've got a couple more to do, including this one. So,
yep. Okay. Well, thank you.
I break them up into subjects for you.
Montana out.
All right. So you think. Thank you. Okay. Montana number 2. Here you go.
Every day, right?
Okay, Montana, your phone just unmuted. Did you have another question?
Yes. Can you hear me?
Yes, go ahead.
Okay, wonderful. I happen to be a realtor, and I own a piece of property that once upon a time was granted under a United States land patent to an Indian allottee. The property is located within the exterior boundaries of an open reservation. The property thus came out of trust from the federal government back in approximately 1912, 16, somewhere in there, but sometime went back into federal trust, and in approximately 2014, it came back out of trust, but what happened is there was no official BLM record to show another United States patent. And so my question is, when you have a property that has once upon a time come out of trust via the land patent, and then there's a mechanism to go back into trust to escape taxation from Montana state property taxes, does that nullify the first land patent? And then when it comes out of trust and you hear from the BLM that they have been prohibited by the BIA directive to no longer issue a land patent on lands that are considered hypothecated on a deed to restricted Indian land, is there a break in this chain of title? Is there a break? Is there a requirement for a second land patent? I guess is.
I'm glad you asked. Here's what you have to do. Here's what I would do. I would go get that original land patent, and if it said on there that if this land patent was ever abandoned, that means it went back to the federal government, and that means it died.
Okay.
So, and if they pass new laws that say they can't issue anymore, you're bound by those new laws. So that's why you need to get the land patent. Now, here's two other sources that you should ask those questions to. One would be the Bureau of Land Management, and the other would be the Bureau of Indian Affairs.
Correct. And the Bureau of Land Management has indicated to me that I need to contact the Bureau of Indian Affairs, both of which are United States subsidiary corporations. And,
that's right. So you might not have any superiority on that land. That's why it's so important to find out what you get before you buy it.
Correct. Yes, and the title insurance policies do not cover, I guess, any claim from a foreign government, aka.
That's right. No, they're part of your title insurance is part of the system.
Exactly. Sure. Understandable. Okay. Very good. So, thank you.
You bet.
All right. Thank you. That's all we have for questions, Bob. So we're going to wrap it up.
Okay.
All right. Hey, thank you very much. And wow, it's a wealth of information. So by the way, everybody listening, we have the Do-It-Yourself Land Patent Kit available at youhavetheright.com. Also, with this kit, we have exclusive audio with Bob. We're going over each part of the land patent kit itself, and I came up with some questions I thought would be frequently asked, and so it's like an hour long or something, but we went over that, and that is exclusive to the Do-It-Yourself Land Patent Kit. So please check it out. Bob, we got another question.
Sure.
All right. When your phone unmutes, it's your turn.
Hi, I don't have a question. I just wanted to say thank you, Bob. That history is absolutely amazing. You are one of a kind, and we all need to hear this. It needs to continue on. Please keep teaching. It's wonderful, and just thank you.
Well, I'll tell you why I appreciate that statement so much. And that is when I first started doing this and laid off 28 people and went and lived in an 8x12 shed for 3 years just so I could afford to study law, and rented out my own home so that they would be making help. I was considered a kook. And I said, no, I'm the same successful guy I've always been. I'm just on a different mission. If you don't appreciate it, it's okay with me. I'm on a different mission. And now I get comments like that, and I really appreciate them because I suffer from those kook statements.
Oh, I'm sure you do, but you've got a great sounding here, and we can't let this die out. It must continue. So I hope you've got books that you're writing and that you're keeping it going forward.
It's already in writing, and it's all over the place. It can't be stopped. It's too late.
Good. So thank you, Tad, and thank you, Bob.
Well, thank you. All right, everybody. Thank you very much for joining up, and tell your friends about us, and we'll see you again next week. Thank you, Bob. Good night.
Thank you, and good night.